Peace. I'm Diallo-Sekou and I'm back. Morris Jury 3, 2013. I guess today I'm feeling like some things I want to catch up on, and here's something else I'd like to bring to a lot of our attention, and that's dealing with trust law, equity. And I hear a lot of people going in the courts and they're using the term executor, administrator over the trust, and they're saying that they're winning. But here's what I'm asking you to do. For those people that are giving me stories and telling these other guys stories about your winning, when you close out your case, please ask for the court records so that we can study and see what you've done to win or to lose in this particular situation. The other thing is this: we have to understand the people that are asking for these templates and everything else. You have to be educated on it so that you can defend it. I tell anybody, paperwork is just paperwork. It's symbolic. You have to know it. And the paper and yourself are also manifestations of what you know. So when the judge says, is there trust? Can you prove a trust? And somebody says, well, I'm the trust. Well, you're at law, and their trusts aren't working at law. They are based on the laws of equity, the equitable side of the court. There's another side. That's the real side. So some clarifications. I wanted to use some notes that I've been getting from NTT, C-Dub, Faith. I appreciate it. And this is just kind of like the explanation on executors, administrators. There's a difference. If you have this book, one is Gilbert. If you have Gilbert's Law Summary Trust, you have to understand that there are relationships. There are primary and there are secondary relationships. So what happens is, I'm going to read this. It says, the need for further explanations because it's not apparent that two relationships being talked about are dissimilar, which means they're segregated. It's made to look like they're the same, but they're not. The key word is regarded as trustee, which makes the trustee look like the same as an executor or administrator, as being the same relationship, but it's not. If you refer to the book Lubes, it's called An Analyst of Principles of Equity Pleadings. Lubes, L-U-B-E-S, An Analyst of Principles of Equity Pleadings. This book was written in 1882, page 174, section 228. It talks about how they are not the same. There is a primary and a secondary relationship. An executor or administrator is in equity regarded as a trustee. Not a trustee, but regarded as a trustee. It means he's similar to the trustee, but you can't have a trustee being the same as an executor or administrator. This is very misleading, and I agree. This is a massive confusion, and it's what they call commingling. The two different relationships regarding what is similar. Regard as one is the duty in at-law jurisdiction, the other one is dealing with regard duty in the equity jurisdiction. Okay, if you look in this book, Gilbert's book, on page 6, there's a section here, section C, that talks about, it's called trust, distinguished from similar relationships. Okay, what's going on is you're looking at it as if it's one relationship or one office, but it's not. It's two offices that are separate. Not even though they have what's called a nexus on the same legal estate. You have to do a relationship test, like it says on page 6 right here. It talks about the office of administrator as another relationship, the office as trustee as another relationship. They're segregated. They both must be kept separate, segregated. You got to have a primary relationship and a secondary relationship simultaneously with the nexus on the same legal estate, or they may be two primary relationships which must be kept segregated as well as the same legal estate. Okay. If you go to, I'm going to read this on page 11 out of Gilbert's books on trust. The section number 7 is called Other Relationships. Various other fiduciary relationships may at times appear to, let me start over. Various other fiduciary relationships may at times appear similar to trust, e.g., guardianships, receiverships, the positions of executors or administrators of estates, even corporate dictatorships, partnerships, or limited liability companies. Each of these differ from a trust in some or all the following respects: the nature and character of title held by the fiduciary, the duties and the powers of the fiduciary, and the remedies available for enforcement. Other bodies of law also deal with special uses for the trust device, such as real estate investments, REITs, R-E-I-T-S, voting trusts, Massachusetts business trusts, and employment benefit trusts, none of which are dealt with specifically in this summary. So, when we're dealing with the executive administrator, we have to know that they are separate. Once the purpose, for example, whenever there's a will relationship to put the legal estate in probate, there's a trust relationship formed for that purpose. Once the purpose is completed, the trust terminates. The will is an indenture. The purpose of an indenture is to trust the duty to place the legal estate into probate and then to administer the legal estate under the statutes and codes, which are two different purposes with two different relationships. Now you have a trustee office as an officer of that particular trust and relationship. Then you have the administrative executor officer as an officer of another relationship. There are two separate offices of two separate relations with two separate purposes. The office of administrative executor does not apply to the trust because the trust relation has one purpose, and that purpose of the other relationship as administrative executor has another purpose. The trustee is an officer of the trust, but administrative executor is not an officer of the trust. Remember, you have settlor, beneficiary, and trustee. Those are the three offices of a trust. Once the trust has been placed into probate, trust terminates. It no longer exists. The trustee and his office no longer exists. The legal estate administrator does not terminate until the purpose is fulfilled in probate. And I think that's the gist of it. But you have to understand that these things are separate, and we can't confuse them, mix them up, and we can't what's called commingle them. If you do, you're going to lose. And I think just a little bit more studying in the laws of trust, learning these maxims of trust, it has opened my eyes to a lot of different scenarios and views of ways to approach court issues, which will be suits in chancery. I'm even looking at a whole nother idea of concept of reparations, dealing with these police officers, school board districts, all these corporate factions that have been dealing or have not been dealing in the right manner of things, but a way of protecting ourselves and the future of the people. Peace.